of Rights, our outline of freedom and protection, does in fact limit our government. It is the very crown of our liberties. The government in the United States is a limited government. The Constitution is filled with examples of this fact. Chief among them are its many guarantees of personal freedom. Each one of those guarantees is either an outright prohibition or a restriction on the power of the government to do something. All governments have and use authority over individuals. The all-important difference between a democratic government and a dictatorial one lies in the extent of that authority. Our rights, however, are relative. They are not absolute. The Constitution guarantees many different rights to everyone in the United States. Still, no one has the right to do anything he or she pleases. Rather, all persons have the right to do as they please, as long as they do not infringe on the rights of others. The right for me to swing my fist ends where the other man's nose begins. Thus, each person's rights are relative to the rights of every other person. To illustrate this point, everyone in the United States has the right of free speech, but no one enjoys absolute freedom of speech. A person can be punished for using obscene language, or for using words in a way that cause another person to commit a crime, for example, to riot, or to desert from the military. Justice Oliver Wendell Holmes put the relative nature of each person's rights this way: the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. Federalism and individual rights. Federalism is a complicated governmental arrangement. It produces any number of problems, including a very complex pattern of guarantees of individual rights in the United States. Remember the Bill of Rights? Our first 10 amendments were originally intended as restrictions on the new national government, not on the already existing states. And that remains the fact of the matter even today. The national government did attempt to modify the Bill of Rights through the 14th Amendment. Again, the provisions of the Bill of Rights apply against the national government, not against the states. This does not mean, however, that the states can deny basic rights to the people. In part, the states cannot do so because each of their own constitutions contains a Bill of Rights. In addition, they cannot deny these basic rights because of the 14th Amendment's Due Process Clause. It says, "No state shall deprive any person of life, liberty, or property without due process of law." The Supreme Court has often said that the 14th Amendment's Due Process Clause means this: No state can deny any person any right that is basic or essential to the American concept of ordered liberty. But what specific rights are basic and essential? The court has answered that question in a long series of cases in which it has held that most, but not all, of the protections of the Bill of Rights are also covered by the 14th Amendment's Due Process Clause, and so apply against the states. In deciding those cases, the court has engaged in what has become to be called the process of incorporation. It has incorporated, that is, merged or combined, most of the guarantees of the Bill of Rights into the 14th Amendment's Due Process Clause. For example, the provision of freedom of speech, freedom of the press, freedom of assembly, the right to petition, the Free Exercise Clause, and the Establishment Clause all are protected under the 14th Amendment. Our protections against unreasonable searches and seizures, cruel and unusual punishments, right to counsel, self-incrimination, the right to confront witnesses, the right of a speedy trial, to obtain witnesses, trial by jury in criminal cases, and even double jeopardy have all been incorporated into the 14th Amendment. However, there are some provisions that have not been incorporated. Examples of these are the right to keep and bear arms, the quartering of troops, a grand jury indictment, and trial by jury in certain civil cases. As you can see, the process of incorporation has not completely brought the Bill of Rights to every state, but it sure has brought most of them.